All right, today's mastermind, we have a guest with us, Patrick Flynn with Flynn Law Offices. We're going to ask some attorney questions, things that agents should know when they're selling and buying and helping clients buy and sell, especially when it comes to some certain things like probates, divorces, deeds, etc. It's great to have Patrick with us. As you can see from this photo on the left here, he's got some experience behind him. If you compare,
That photo's really up to date. It's right up to date.
I wanted to show the experience level without showing the experience level. Now you look good. You still look good, Patrick. So thanks
I appreciate that.
for joining us. We'll get started. I have some questions for you. The way we'll do this is I've got some questions for you, and then I know you probably have some things you want to share, and then we'll open it up to some questions from anybody that's watching.
Sure.
We're recording this so we can share it with anybody else who wants to take a look after the fact. So let's get started. So before we begin, I thought this meme was kind of cute. Why did God invent lawyers? So that real estate agents would have someone to look down on.
It's pretty good.
It's a good one, right?
It's pretty good.
Yeah, I thought so too. So I thought it was fitting. So first question, why is it important that agents suggest their clients use a real estate attorney they can trust? And keywords there are real estate.
Yeah, I agree.
I mean, what do you think, Patrick? Our family law?
Yeah, no, I agree. I mean, so
Are family attorneys great at closing real estate transactions?
yeah, probably not anymore. I mean, it was a day and a time for that, right? Like everything else in life, things have got more specialized. You go to your primary care doctor and they ship you off to a specialist. That's kind of how everything has gone over the past, say, 15 to 20 years. Everything's got a little more specialized as to what you're going to do and what you're going to handle. So it's important that you're using a real estate attorney, that's someone, especially in this market, someone that's done it before. A lot of times you're going to get, oh, my cousin's an attorney, he'll do it for nothing, or my father's friend, but which may be okay. You just want to make sure that they've got some experience doing real estate.
Okay.
You wouldn't want to put me. I don't travel into areas that I don't belong either. So just kind of how that works.
So if a client was to ask, say to an agent, I really want to use a family attorney we've used for a while, what would one sentence be that you would share with them, that the agent should share with them to just kind of steer them away, or at least get them a conversation with someone like you?
Yeah, it's usually a good thing that, especially with that, is just to find out. I guess the question would be is, okay, do they do real estate? Like that's like the big question to ask them. When was the last transaction they did? You can ask them their name first. A lot of times the name might, they don't know the name, they find the name, then you know who they are, and that's okay. But that's really part of it. Do they do real estate?
For sure. So, for the agents watching, it's just kind of asking more questions and just saying, the things you can risk by using an attorney that's not used to doing real estate is delays in closing, meaning, you could be, living with your in-laws for a week if things don't go right.
Right.
Right. Deals fall apart when the right people aren't involved. And we've had deals fall apart where it just didn't make sense what they were arguing for. And it just.
Yeah. Some litigation attorneys treat the purchase and sale negotiation like a litigation. It doesn't, you don't get to that point where you need to be. So it can become difficult.
Awesome. Also, why is it important to get an attorney involved early in the process especially when you're listing a house?
Yeah, well, the earlier we're involved, usually you can find any issues right away and deal with them head on, supposedly as opposed to the end of it.
For sure. I mean, I would say even before listing, if you sense anything might be off, meaning they've been late. For right now, what we could see people that are in forbearance. What does that mean to their payoff? It could be people that inherited a home, divorces, separations where they want to sell, anything where it's not clean and cookie cutter, which, is probably over half of the deals out there.
Right. Seems that way at least. Yeah.
Get an attorney involved quickly. Refer them, to the seller and say, I know we're going to be listing the next couple of weeks. I want to connect you with a good attorney who can help make sure that we handle everything right. And they can do a quick title search to make sure there's nothing we need to clean up before the fact. I mean, do you guys typically do that
Yeah, it's usually you can run up the deed, quickly just to see if there's anything out there. not so much a full search, but you can run it up, and that's a pretty good idea. You can see there's a tax lien on there, and
Yeah.
some of the stuff we're going to talk about today is on point as to why you want someone there early.
Okay. For sure.
Divorces, probates, those situations really should get someone involved up front.
For sure. So get an attorney involved early, and you can save yourself some headaches for sure. All right, let's get away from this meme. I know you want to get on to the next page.
I like this meme. This is good.
All right, types of deeds and what agents should know. What type of deeds do most buyers want to consider when buying a home, and why?
Yeah, the majority of the time you're going to get a quick claim deed.
Okay.
And the quick claim deed, I know.
What is a special warranty deed? I hear that come up every once in a while.
Yeah, that just has just it warrants the deed itself and covenants. But in Massachusetts, a quick claim is the way to be. So it's kind of a weird. You'll see if you're doing any national training or you go to these national conferences, you touch on this. Other states, a quick claim deed is probably the worst form that you can take because it comes with no warranties behind the deed itself, which is title aspect of what would be defended. And that's not the case in Massachusetts. It's just the opposite. It's just one of these state to state things. So a quick claim deed in Massachusetts is really how you're going to take it. A lot of times you may take it as a fiduciary deed is another common one you'll see, especially if you're getting it out of an estate.
Okay.
Because you're taking a deed from an executor or a personal representative of the estate, so they can give you a fiduciary deed. So most importantly, when you're taking a deed, most of them should be quick claim, and we put for that in the purchase and sale agreement. That's in there. That's why it says it right in the standard agreement that's how seller is going to convey title. That way we know right off the bat.
Okay. Why would it be important for an agent to actually read the deed when they're getting ready to list a property?
Oh, they want to know who's your listing agreement going to be with? Who owns the property?
Right.
You want to make sure that your seller is actually the person you're talking to.
Can they trust MLS public record with the assessed owner, or should they still be?
You can try. Assessed owner usually follows the deed with the tax records, but they're not always up to date. So it's always good to take a look at the deed itself. That will give you some idea of what's on there, depending how much you want to read into it. But it will give you an idea. I mean, obviously, if and then you can prepare yourself if there's any title issues as you get going with it. As you get, for example, you're dealing with someone who's a single person living in the house and there's two names on the deed, you might want to know who the other person is. Right. When you look it up, so you can find out ahead of time, is that who that person might be. So, former boyfriend, a widow, spouse, former spouse, whatever it might be, a brother, father, sister, everyone's got different names on deeds. So it might not, you're not going to catch everything, but it certainly will help you get an idea of who you're dealing with and who you're going to have to deal with, especially when it comes time to sign your listing agreement.
We've had some weird ones where, they names didn't even seem like they were relative on the deed, and people are trying to sell the property. And I mean, it's a good idea to just check those things for sure and make sure.
Yeah.
But also for me, what I'm looking for in the deed is a description of the land. Does it sound like it's similar in size to what you're seeing on MLS records, public records, et cetera? It didn't work out because the seller was a crazy person who was squatting the property, but I had a buyer who was looking at a foreclosure, and it was listed as 1 acre. And that's what it was being bid on, but the deed referenced 3 other parcels that were going with the property. The buyer would have gotten 8 acres with 5 extra buildable lots, A&R lots ready to go. The only problem is the guy had sued everybody, including the government, to try to stave off foreclosure, and it was just going to be it was going to be a multi-year wait and fight to ever get the property, so he decided to back out. But find differences of this owner may not realize what they actually own. Not to mention easements also. When you're listing a property, you want to know if there's any easements. The seller may not even know.
No, they might not. And sometimes those are listed on the deed if you're in the deed, or sometimes you get property, especially we've had deals where we've had property in both Massachusetts and Connecticut, where we are down this way, because you may have a piece that has a small piece in one state or the other, and they might not realize that, or even pieces in other towns. That helps you to understand that there's another town involved, and that changes some of the aspect of it. And this goes for both sides, both buyers and seller side. Helps the seller know what they've got to sell, and it helps the buyer understand what they're going to have to go through in the process.
Right, exactly.
That they're in fact going to have a small tax bill from the state of Connecticut, or 2 towns are going to have tax bills, or whatever the case may be. So it gets more information out there. That way, they're not showing up at some point during the closing and oh, this is what it is. They understand it a little bit. Right.
And for us too, it's like even if there's a drainage easement or a utility easement, you always want to dispose that stuff up front, because even if it's not a big deal and an impact on value, if the deal's already under agreement, you know what the buyer's going to do. They're going to
Right, that's just it.
money,
Yep.
money off the deal. So it's amazing how many people actually don't know, don't remember they bought the house 10 years ago. The utility easements never bothered them, and they forgot that there even was one there, and they want to list the property. And if you don't check it out and see those things, you could be dealing with it later. So just
Right,
it's a good idea that you're not going to know every word on the deed or understand what it all means, but it's a good idea to read through them when you're listing a property. And if you see something that's a question mark, just bring it up to an attorney like yourself, Patrick, or bring it to my attention, and I'll try to help you out with it as well. So, all right, let's move on. Clients are getting divorced and they're trying to sell their home. What should agents ask when their clients are getting divorced or already divorced or want to sell their home?
yeah, so divorce, that presents, of course, a couple different problems, and it always depends on what stage you're in the divorce, with that. So the first thing to understand that if they haven't filed divorce yet, but they're getting divorced, then it's still really marital property. There's really not much else to it other than you really want to make sure that you're getting both people signing on that listing agreement, right? Because you need both. If they're both on the deed, they both need to sell. It's a good idea to have that involved.
If they're not both on the deed, they probably should both be signing it, correct?
I'm sorry?
Even if they're not both on the deed, they both probably should be signing it, correct?
Yes, because it's marital property, especially if you know there's a divorce situation, it helps to have that. You want to have that done, because what happens is once they do file for divorce, there's some rules that come into play. In the probate court, they have this rule called the Rule 411, which is the automatic restraining order. And what that rule is it prevents anybody who's filed for divorce from dissipating any assets unless it's done by a couple different triggers. And one of those is agreement by the parties. So a purchase and sale or an offer signed by both parties gets you around that. So you don't have to go back to court to get permission to do so on every agreement. But it is important that you know who you're dealing with and you get everybody to sign, because, you don't want someone thinking, and divorces just can take different paths, and so, someone may want to list it with you and someone may want to list it with a different agent, and so you don't want to get involved in that. You want to make sure everyone's on the same page and kind of tread lightly with that, because make sure everyone wants to sell. There might be different reasons, why they're trying to sell or not sell. So once you hear the word divorce, it should trigger you to know that's the case. Ask some questions. Are they represented by counsel? Because they might already have a family attorney that's involved. It might be a good idea to talk to that family attorney or just ask permission, to the client if you can talk to the family attorney. That way you get a good idea where they are in the process of getting ready to list that house.
Yeah, for
Sometimes
sure.
they tell you up front, but it's a good idea just to know what you got going on.
Yeah, for sure. I mean, I know it can be tricky. If you're talking to one party, typically the other party doesn't want to necessarily, if they're not in agreement, then they don't want to talk to you either because you're guilty by association. So
Right, it just happens. I mean, I think you and I have one.
Based on which side you're on.
Right. No. I know you and I had one personally where we had a court ordered sale for one side, remember? And, we had to bring that guy to the table. It was tough getting everybody on the same page for that deal, and that happens.
Is that the one where the other party didn't sign the offer and they had to basically convince that person to show up and sign it?
Yeah, because the court had ordered the house sold in a court order, because sometimes, in divorce, again, it's because it's such a tough situation. People handle it differently. You're dealing with people. Some people just, shut their eyes to it, so they're going to not respond to anything. So now the house has to get sold, and there's a judge that you set up a court date and one side doesn't show up, and now there's a court order that says the house has to be sold, and now we somehow have to get that person to sign, or you have to go back to court to ask the judge to actually dictate the sale, which can happen. But you're trying to avoid those types of situations because it's time and money, and so those are the situations that can arise when you get a divorce situation.
Sometimes the court will actually end up deciding what happens, right?
Right, that's exactly how it goes. I mean, sometimes it's the parties, and sometimes it's again by court order. Yeah. So you just it could be the easiest way is they have an agreement. They everyone's communicating and those types of things. Sure. And then it's important to know again through the process who's representing the different parties. Hopefully, they each have counsel. As a lawyer, we like to act as counsel, kind of for both of them in that regard. When selling the home, we have one slim focus. It's just completing the transaction, but we're actually taking direction from each of their attorneys which is very helpful in
Right.
smoothing the transaction.
All possible. If you're talking to both parties early on, it's the best case scenario, because the longer you talk to one party and not the other, the more of a chance you stand of not getting that deal if the other side thinks you've been cohorting behind the scenes with
That's correct.
the person.
Yep.
It's
Yeah, transparency is the best way on that.
for sure, but it's definitely important, because you could put in a lot of work and even have a property listed, and all of a sudden they go to court and you no longer have the listing.
That's right. That's right. You want to make sure that you're, whatever stage you're in, you're trying to communicate as much as you can and being transparent.
Yeah. So I think we already kind of talked about the marital rights question, but basically anybody that's married has some level of marital rights to the property, whether they're on the deed or mortgage or not.
That's correct. Yep.
Something to definitely know in Massachusetts. Anything else as far as divorce that agents should know?
I think those are the real coverage thing. Again, I think it's good to be, if you just remember, you got to be transparent, not take sides, and then just sort of, it's really dealing with people, and as agents, you're trained to sort of do that in your own way. And so that's how you really have to handle that with each person, but understand that you're going to be a little more work on that deal. You're probably going to be dealing with, but potentially three different attorneys, at least on just your side, trying to get it done.
Sure.
So it's a little bit more to bring it to the end. And then of course, at the end of the day, some of those things can get kind of crazy at the end when you're trying to get your performance done on the purchase and sale. So I tell people, try to limit what you're promising up front, house is going to be clean, or this is going to be moved, those type. A lot of times it doesn't get done at the end. It's very difficult for that to happen.
I was going to bring that point up. In some cases, it's kind of like selling a short sale property, and you really have to have their agreements up front that they're both somebody's going to clean up the property, clean it out when it's time to close, get rid of the trash, not leave bills, because we've seen that time and time again, that one party feels like they got screwed, so when they're moving out, they just make a total mess. And
yeah, that's right on.
or they don't pay certain bills, and then it leads up to closing. So definitely something that that's where our full skill sets come in as real estate agents when you're dealing.
That's right. That's right. So just be prepared to expect the unexpected in those cases.
Absolutely. All right, let's move on to probates. Clients inherited a home and they want to sell it. I don't know how many times we have this situation come up, and someone inherits a house and they said, I was the only one in the will, let's sell it. Right. What questions should agents be asking clients when they say, I've inherited a house and I want to sell it?
Yeah, this is always a good one. Especially right now, because
every inherited property need a probate?
No, it depends. Well, so inheritance is kind of a catch-all word. So there are situations where, mom and dad, or, let's just use that as the example, created a trust, and so now the property is in a trust, which is a little bit different, but it's still quote unquote inherited. Or that they already put their children on the deed, ahead of time, understanding that they wanted to avoid going to a probate court. So they did that. So again, it's inherited, but they're already on the deed. So you can, checking out the deed, looking at the property is a good way to know whether or not it's in a trust up front, or know if they've already owned it may have some ownership interest because of the way the deed reads, So those are two situations. But if it's a straightforward, that there's not a trust, or that, some other entity that's holding the property, or if there's not joint tenancy with someone who's still alive, then yeah, you're going to have to probate to some extent. And so the probates, that gets a little bit, it's complicated to a certain extent, but it's really just transactional in nature. So, the first thing to obviously find out is, have they started a probate yet? Or are they in the process? Usually there's an attorney involved with that. A lot of times, the probate attorney will also will do some real estate. I mean, that's not uncommon, or vice versa. Some people don't. You want to make sure that's the case. When you're asking those questions, that gets back to why it's important to have an attorney involved. And then understand the timing. Right now, because of COVID, these cases are awful. I can tell you right now, it's just taking months and months and months.
Months to get a license to sell.
Yeah, license, or even to get a probate filed or started, or anything. It's just a unfortunate situation. And it's not just in Worcester County that we primarily are in, but all over the state. We're finding, even if you're walking in, everyone's short-staffed, or they're staffed 1 week on, 1 week off. Everyone's handled a little bit differently. So things are just not going as smoothly as they probably could. Judges aren't there all the time like they were before, so getting stuff signed by a judge isn't there. You just can't walk in to have a hearing, on a Friday afternoon like we used to be able to, or get things done. So
Right.
there's a little bit more time frame that's involved, and so it's really just trying to set your client's expectations that on both sides of it, that if you're selling the house, it's going to take a little while, and if you're buying it, this is going to, and the probate hasn't been started yet, you're going to be in for a little bit.
Yeah. So as soon as someone says I inherited a house, they should be talking to an attorney for sure.
Yeah, no, without a doubt. Yeah, they should. There definitely has to be a probate. I mean,
And the license, that's just basically an okay. It's an okay to sell from the probate court, right?
yeah. So license to sell really only occurs when you die, what they call intestate, or you don't have a will.
Oh,
So if you don't have a will, you don't have any powers granted to you. So in order to sell the property, you have to get permission to do that. You're appointed administrator, and then the administrator has to file a license to sell, which requires a few other steps depending on the way, depending how it's done. And that can only happen within the first year from the date of death. And after that, it's a little different. So there are certain standards that have to be met. So yeah, if they could have already filed the probate, and the probate could be open, and they're just waiting on the license to sell. You can't get the license to sell until you get a purchase and sale agreement. So you kind of have to get that far down first before you can get the license.
sell before you have a purchase and sales agreement.
Right. So, if they died with a will, then no, the will, most wills, hopefully, especially things that have been current, would give the personal representative the power to sell. So as long as that's in the will, then they'll be able to sell the property without having to go back to the.
Are there any requirements of that will to be valid? Does it have to be notarized? Does it have to be?
Right. So yeah, I mean, that's all part of the title search. So that's what comes up down the road. You're not going to know that up front because, again, it's good to know where they are in the probate process. Has it been filed? Have they been given? Especially they're going to sign your listing agreement, right? So someone calls you up because they want to list their parents' house. There's 5 brothers and sisters, and you don't realize that you're walking into a contentious situation. And again, you want to know who has the ability to sign for that. So there's certain things called letters of authority, or the buzzword is personal representative, who's been named personal representative of the estate. If they don't know that, or they say, oh, it's pending, well, then they're really trying to list that house a little too soon. They got to get into probate court to get things started.
Right.
Because it legitimately right now, just to even do a simple informal, and it's probably 3 to 4 months, which used to take you like a month.
Yeah.
Yeah, just time wise. And so right now in this market, I mean, in this area, you're going to be waiting around forever. It's going to really prolong the transaction. So it really needs a little bit more upfront with that in terms of getting named personal representative. And it's assurance too as the agent, because who you're dealing with has the authority to act upon the estate.
Is it a good idea to either ask for a copy of the will or say, it'd be great to have a real estate attorney look at the will to make sure it.
Yeah. So what will happen is, I mean, obviously, if they have a probate, some of those questions that come up, if it's an estate, I should say, is, do they have an attorney yet? Is there an attorney working on it? If not, that's your chance to try to get it to someone maybe that as an agent that they can handle that portion of it. Again, if they practice both of those areas, and that way you can get the process sort of going. If you have a potential listing and you have a question, then call an attorney that to ask find out what to run it by them. Before you even take on the listing.
An attorney that?
Well, say I do. We handle probate. We have for a long time. So it used to be a lot easier than it is now. That's for sure. But yeah, I mean, it's always something that we'll get calls on often. Is what stage are they in?
Right. I mean, I have to assume that some people say, "Oh yeah, I have a will, and it was left to me," and somewhere later down the line, someone does a title review on that, and they're not in agreement. Can that happen? Yeah,
it can happen. I mean, title stuff comes up from time to time. You just never know.
It's just written on the back of a notepad, and it's got a signature on it. And
right. I mean, so the process is when you do the will, that doesn't really get filed with the court until the time of death. And so there's a process. That's what you're going through probate for, is the allowance of that will. And so when you're involved in that process, if you're listing the house prior to doing any of that, then no one really has the authority to act for the estate because the will hasn't been allowed. They have not been named personal representative. So they have no authority to act. They may think they have authority, but they may not. And again, there's something in there called standing, which means whether or not you have the right to be personal representative, and there are issues when that arises. And again, families often disagree during the estate process. So it's important, I think, as an agent that the best case scenario is that the property is already started. You've already started the probate process, and you're getting ready to sell the house. So that means that someone's been named personal representative. Anytime you're doing anything without that, you're taking the little bit more risk as to where you are in the process.
I see a lot of those deals get messed up over my 15 years, and it's usually because there wasn't involvement early on with an attorney and figuring out, can they put it on the market? Do they have right to list it? Is there a probate issue? Is it going to be a problem getting a license to sell? All those things have either delay the closings or kill closings more.
Right.
Probably more a higher percentage that have issues than don't have issues.
Right. Because again, you can't trust that people, other than the fact that they just don't know, understand what they have to do. Most people don't understand the process behind it. And
what happens if someone comes in and contests it?
Yeah, no, then the whole thing gets held up. So that becomes a problem. Or if you're going to get a license to sell, we try to get a sense from everybody, so meaning that the interested parties have assented to the license, if they haven't done that, then you may have to publish citation. You have time frame for that. Someone may contest the amount of the value or who you're selling it to. Is it an arm's length transaction? Those are things that can be done at hearing. And so, it doesn't happen all the time. Usually when you're talking estates for larger estates, there's a larger dollar amount at stake. That's usually when those things come into play.
Right.
But those are things that can happen.
Right. Okay. Great. Any other probate points that you think should be mentioned?
Yeah. Again, like I said, there's a process there, so you just kind of have to let that play out and understand there's going to be a little bit more paperwork to sign. Yeah. There's a few more things involved with it.
There's just more potential roadblocks just to make sure that everything
really
the way it needs to be, and that you start early on is probably the key to success. Really, is just
that's just it.
Getting the proper people involved and just making sure you don't just wait until you have it under agreement to figure all that out.
Right. It's just setting up expectations. Like I said, when you said something earlier about a short sale, that's you don't set up the expectations of someone on a short sale that they're buying that they're going to close in 30 days.
Right.
And you don't want to do that with an estate property either. Those are not going to be simple, depending on where they are with it. Even when people come to you and say, I've already been appointed, this is a slam dunk, it's easy, there might always be something that comes up because it's a probate issue. You just want to make sure that that's the case.
For sure. Absolutely. All right. Awesome. So let's move on. I know you said you had some things you thought were going to be useful information for agents out there, and then we'll take some Q&A. We've still got some time left. So are there some other things that you see happening right now that agents should be careful of or aware of, or what would be your top 3 pieces of advice for a real estate agent in the market right now?
Yeah, it's such a crazy market. So to me, the biggest part up front is, and it just really generalities on how you want to run your business. But I think that the number one thing is setting your expectations. Number one is in there. What are your expectations with your sellers and your buyers? Where you expect to be with time frames and what should be happening. Don't go into people setting up offers with 30-day closes or on bank deals, or USDA transactions for 30-day close or something like that. You're just going to put your buyer in a tougher spot down the road because or even even your seller, you're setting expectations it's going to be a 30-day close. It's not going to happen. Those things are just few and far between where that's going to come to be. The big thing is communication. With what we're doing and keeping everybody informed as possible. So that what that really means is making sure is when you talk to your client that you've got everything in the offer that's supposed to be there. That's the old one where you don't just write appliances per MLS, list them out so we all know what they're going to be. If there's any type of transaction that's supposed to happen, let us know so we can deal with that issue. We had one the other day where the seller is in Taiwan and has to get a deed, couldn't get an appointment for the embassy. It's supposed to close tomorrow, and they went down Thursday thinking they just get their deed signed, and they can't. No one told anybody that was the case, and so we're all sort of scrambling that on our end with the buyers. How does that work? So so the communication part and what on those ends is important for everybody in the transaction. In terms of that.
For sure. Expectations and date protection is huge right now.
Right.
Everybody wants to sue everybody for anything they can right now. So the amount of threats of suit have increased tremendously in the last couple of years. Is just, and unfortunately, it's the escrow laws in our state don't make it any easier for either party to get the money. But it doesn't mean that we're not seeing more arguments coming up where, we should get the deposit, you defaulted, we don't agree.
Yeah, you're just trying to save yourself. All those things down the road, you're trying to make this, like I said, when your expectations are set and things are there, things are going to happen, but the dates are there and they're important, and it's important. The other thing is to understand what you're putting into that offer, what that means, so if you're not doing a home inspection, understand that you're at risk, and understand that.
Here's one point I would say on that. And in lieu of an inspection, I would press the seller for a statement of property conditions.
Mm-hmm.
You know what I mean? Not always going to get it, but at least you could lean on that after closing. If there was a gross amount of water that gets in the basement every week, and you decide not to have an inspection, the inspector might have figured that out by looking at chalk lines on the wall or something.
Mm-hmm.
And then you could have, brought that up at that point. But if you're not going to do inspections, if at all possible, I would push for a seller statement of property conditions. But again, it's a competitive market. So it's like, we're in this like tug of war with minimal language possible to keep it a clean offer versus protecting the buyer, and it keeps tugging towards the end of not protecting the buyer because you have 15, 20, 30 offers on every listing. But it's tough right now because we built a whole addendum A to go with our offers, got a lot of great language in it, but I'm suggesting you try to condense it into the second page of the offer, because the longer the offer, the more it's probably not going to look favorable to the seller. So it's really a tough situation. Have you seen anybody making non-refundable deposits yet?
I've had some people look for some of that and some people shy away from it, but I have seen, we haven't hit that point where I'm kind of surprised we haven't hit that yet, which is more or less the purchase and sale is not open to negotiation, right? This is it. So take it or leave it, and don't look for anything else. Don't give us an addendum. Don't ask for anything.
I'm surprised too. I'm surprised that hasn't happened yet.
Yeah, I really thought for sure last spring that might start cropping up, and it really hasn't to that extent.
Would you be heartbroken if we went to a standard P&S that everybody uses, kind of like in some parts of the state?
Yeah, that's fine with us. The biggest problem is those all get changed too. So in Western Mass, the agents will send us the purchase and sale to give it a quick glance beforehand. There's always 3 or 4 changes that get added. Or look to be added, and even in other parts of the state, there's addendums and riders that get put on there. They do it the general standard form or standard Boston, Greater Boston form, and the next thing you know, there's 3 addendums on there for there's the COVID addendum, there's the everything else that their addendum A, the buyer's addendum, so that gets changed so much as time goes on. So that makes, as an attorney, it makes no difference to me, other than the fact that we all like to think, at least in Worcester County, that we all do a certain job that helps out. So I always feel like I'm best suited for negotiating that purchase on the contract, because some of the legalities with it. Yeah. We do a good job of other things that we need to get done, and you guys, for most of our agents, do a great job doing the sales stuff, right? You're bringing the clients in and getting them there, and if you're a good agent, you're teeing it up so the attorney doesn't have to reinvent the wheel and go back and try to fix things that we've made problems. And that's a lot of times we get our own self-made problems, putting the wrong dates in, not listing something that should be on the purchase and sale, those types of things. And you can't change it at that point. And so, we try to do that job so that you don't have to do as much of that, with that part of it, or at least on our end.
I think that's their agents are waiting too long to get the attorneys going with the PNS. So they finish inspections on day 10, and then they're trying to get PNS signed by the 14th day. And
Right.
there's not enough time. They should be, well, I mean, they should really be getting the PNS going before the inspection is completed.
Yeah, for the most part, we like to get an idea of what the deal is ahead of time, so we'll get a copy of the offer over, and then, our first, in our office anyway, it's to really follow up and say, okay, let us know when the inspections are over in case something changes. And then
At least
really it's just adding a few things in there.
right. At least you're not just starting out day 1 on the file on day 12. You know what I mean?
Right. No, you don't want to get involved in those situations. You're trying your best to avoid that.
Yeah, to me, too, agents really have to be careful of the dates just as much as the attorneys do, because if your mortgage contingency date slips and you didn't request an extension, more and more so sellers are going to hold you accountable to that. Same thing with response dates. You got to be careful with those. Those are big dates. And I even on the PNS, I don't know how many times I've seen attorneys be very lackadaisical about it, like, it's not a big deal. It was supposed to be signed yesterday.
Yes, you're trying to get extensions on that. I mean, there is case law out there that talks about, if you've been trying to negotiate it back and forth on a purchase and sales, and so it's not as important as if, there was complete silence and things of that nature. But, you try to get at least some acknowledgement, nowadays, emails are sufficient, an email over to the other attorney.
Both emails said, yeah, we're agreeing to extend a few days, 3 days, then you're okay.
Right. And that's usually what we end up doing in those cases, if it comes up that there's a problem, that we think we need another couple days to get things resolved, or hunt someone down a sign, or, those types of issues, those types of concerns,
Yeah.
But it's important that you're again, if you feel, then go ahead and ask that, go ahead and ask for that extension,
Absolutely. What else you got before we open it up for some questions?
I'll take any questions. Anyone got any questions? I think that's pretty good for me at this point. We've kind of covered a lot of the deed stuff and everything else.
Questions, if they have questions, I'm going to open it up to everybody else.
Sure.
All right, any of you guys have any questions that are online right now? I've got one question. Well, anybody else might be thinking about their questions, but there's more and more I'm hearing buyers, like after closing, having major issues, saying this wasn't disclosed to us, the basement gets water all the time. What do I do about it? Do I have any recourse?
Yeah. I mean, there are things that need to be disclosed, and if they weren't, then you have recourse, but you have to litigate. It's
even
it's
if
like
there's a sour statement of conditions, is there still potential recourse?
it's tough to, you can get that, but you're really relying on your own due diligence, so.
From what I've understood in the past, you'd have to have contractors come in and basically put in writing that this had to have been happening for a long period of time, and not just with a freak storm, right?
That's right. So groundwater is one of the toughest things to prove.
Yeah.
At any point. You really almost have to prove knowledge with all of these things, or, intention, and that, you as the homeowner or the seller knew that you had this water problem that you tried to hide, or that you got water in the basement. You affirmatively said that there wasn't water in the basement during questionnaires. And then you really then, as the plaintiff in that case, have the burden to prove that this house, that the sellers did know and hid it, that there was water there. And that's a very tough case, tough claim to prove, and so.
I can imagine any of those kind of things are probably pretty tough to win after you close.
Yeah, it really is difficult. Anything post closing can be difficult. You're trying to get everything done. That's why we try to explain, the walkthrough is so important at that time, and what's gone on during the house at that, if something isn't right, it's important we get it right before you close, because anything post closing, there's no leverage. You've if you're the buyer side, you've got no leverage on it. At the same time, at the seller side, no one wants to deal with your seller calling you up 2 months after the closing that they got these, litigation papers in the mail, that someone got, they have to deal with that. And, ultimately you can't help what other people are going to do if they decide to sue or something to that effect. But, the reality is that, these are hopefully things that come up, at the inspection or the walkthrough. Again, and you have to understand that. I mean, people, especially now, one of the reasons you have that is people aren't doing inspections.
know.
So they're not gonna have an inspection. They don't think it's worth it, or I'm not gonna have one. My dad's a contractor. He'll come in and look at it.
Well,
There's it's different looks.
Modern day inspections too. The inspectors, the buyer pays $500, $600, $700 for an inspection. And a lot of times in the basement, they'll say, if you have any further concerns, you should seek advice, seek out a basement professional. They don't like to put a label on a basement. So,
No, and no one does, and not in New England, because it changes. It just changes over time where your water levels change. I mean, it happens, there's case law on point, there's stories on point. I mean, the house is dry basement for 30 years, and then all of a sudden they put a development, a mile down the road, and that changes the water table because they changed out they built up ground or something to that effect, and now the table's changed, and now you get water in the basement. I mean, those things happen and can happen, so no one wants to put their full on it.
Yeah, for sure. If I'm walking through a house that's 30, 40, 50, 60 years old, I mean, I'm typically just, telling buyers, looking for water issues that would cause excess water to get into the basement, gutters, drainage, slope of the ground away from the house, things that would add excess water to the exterior of the house that could get into the house. But beyond that, I'm like, look, I don't see a lot of evidence that there's water marking or water getting in here, but it's New England, and and nobody can guarantee you that you're never going to get water in here. You can do things to prevent as much water as possible from staying around the foundation. But other than that, there is no guarantees. And, that's the tough part. I mean, buyers look at a 1960 ranch and they're like, oh, I want to finish the basement. And it's a cinder block foundation. You know what I mean?
Yeah. No, it comes down to that communication. And again, and the reality is, I mean, once the deals are done, it's very difficult to reopen it, and there's purpose for that. We'd be in court all day long with cases like that if the laws weren't the way they were. So, like I said, when you have some of these issues or disclosing issues, it's not so much that, it's whether they knew or not, and I think that comes up less often than you think, just
sure.
when that comes up.
Anybody else have any questions from the group? Here's another question for you. Now it just slipped my mind. Permits. Do you recommend the agent look through the permitting or find out if there's open permits? Do you recommend the buyer do that at time of signing PNS? What do you think about that?
Well,
it's a hot item lately, especially with basements.
Right. So a lot of times, if you're fortunate, I mean, you're finding appraisers catch a lot of them.
Yeah. Okay.
When they're going through the appraisal process, whether or not there's an open permit or not. If you know that there's work that has been done, and especially in a basement, it's always a good question. It's a good question to ask if they have any permitting done when they did anything else other than the original house.
Especially if it was done within like what would you say, the last 10 years?
Yes. Yeah, exactly.
If it was done 20, 30 years ago, the chances are there probably wasn't a permit.
That's right. That's right. But you may want to take a look at it, or if the home inspector looks at the deck and the deck looks a little suspect, and they say they just replaced it. When did they replace it? Those types of things.
I mean, the indicator of that is if you look under the deck and you don't see lag bolts into the house.
Right.
They say they got a permit. That probably probably didn't.
Right.
But there's signs obviously if you have enough knowledge. But it's just it's an interesting time where you have to be great at your job as a real estate agent and an attorney to avoid yourself getting into hot water later, right?
Yeah, you're just trying to cover all the bases as much as you possibly can, but so you're just trying to find that line between protecting your client and kind of going overboard with some of the stuff that just isn't going to happen. But you know, it's good in the beginning to know that if, you know, there's been, you know, looking at that property, you know, that's the one disadvantage as attorneys we have. We don't actually see the property, you know.
Yeah.
We're looking at this from a standpoint of meets and bounds description on a plan of land, you know, and then what the title and the history of it has it. I'm not looking to see what the siding looks like or the roof or when the windows are replaced or anything like that, you know, with the property itself, you know. So we're kind of not seeing those aspects of it. We only know about it if we're being told or understand what they're trying to do. So sometimes we get a better description than others.
Sure, sure. Any legal language that you are recommending agents use either in their listing sheets or anywhere for that matter? That will protect them or protect the client?
Yeah, it's always, it is good, you know, if you're gonna make something subject to something, that you kind of finish that off with, you know, then all deposits will be returned, you know, herefore refunded, you know, there's some language to that regard.
That in our offer, which is subject to mutual agreeable purchase and sales agreement.
Right, like,
You know, in the past that there has been cases that were tried that they considered the offer to be the contract if no P&L.
mhm,
So we did add that language to our contract.
yep.
That's
So it's important.
for any agent to have, is that subject to suitable or subject to mutually agreeable purchase and sales agreement.
Right, that's important. I mean, it's so important too. We tell people all the time. I mean, the toughest one we see a lot of it lately is the buy and sell, you know, at the same time. And we're not putting in language that says, you know, contingent upon seller finding suitable housing or the buyer selling their house by a certain date. You know, those things have to be put in there because if they're not, we're running into problems. You
Yeah.
know, and I see people doing that. You know, unless your buyer is certain they're going to have a bridge loan, because they're not going to sell their house in time.
Right.
Or something happens. You know, we've had deals like that in the past. I've been on both sides of those. Where, you know,
You got to be a little bit careful when you're reviewing offers from a listing standpoint too. I know there's some people that are just kind of buyers that are willing to take that risk. They don't put subject to closing on the sale of their home, and they're just kind of taking that risk. At the end of the day, they might be putting their deposit at risk, but your seller might be put into a situation where they get to the closing table and the buyer says, well, we can't close yet. We haven't closed on our house. And that's the first time they're hearing about it.
Right,
Whether
right. No,
actually ever gets that deposit money or not, the seller's still in a sticky situation if they were closing on a home or something.
right.
You almost have to, I mean, ask those questions. Your buyer's not selling a home, correct? Because even if they don't have the contingency in there, it doesn't mean they're not selling another home. I mean, it's a valid way of trying to get an offer accepted now, not to put the sale contingency in there, but you know, and some sellers are willing to take that risk, you know, or some buyers are willing to take that risk.
Yeah.
Contingency in there.
Yep. Yeah, no, you really kind of have to be careful with some of that because then it becomes a tricky problem at the end and everyone's trying to.
Or cash offers that really aren't cash offers. They never had it.
Never had a cash offer, and then someone calls you to do an appraisal 3 weeks later and you're wondering why.
Yeah, exactly.
Yeah, that's not cash. Or
we know how hard it is to keep deposits. So
yeah,
taking those risks out there. So you got to have an eye for, you know, digging into the details of the buyer.
Right.
Even if it looks like the best offer imaginable, you know, it's like, we had one recently too, that the agent, you know, put in the language of we'll cover the additional deposit if the appraisal doesn't come in at sale price. But then they were all mad that they didn't have an opportunity to sell the appraiser on the value at the time of appraisal. You know, it's like, so you got to dig in a little bit. And also, a key one for me is the language in the listing sheet that says buyer agent to confirm all listing details and do their own due diligence, because we've run into situations where the square footage on the appraisal was 100 square feet different on the MLS listing, and then all of a sudden the buyer's looking for $50,000 off the price.
Right. I've had that come up lately with the appraisal with square footage. It's been interesting. Some square footage numbers in MLS are just, whether it's just sheer laziness or getting from the wrong spot, they're off from the appraisal or they're off from.
Yeah, I mean, it's almost an idea to take some quick measurements as a listing agent now, because most of the listing agreements, they're pulling the details from the public records, which is pulled from the assessor's office. And do the assessors really care if they have the exact right square footage? No.
Yeah, it's funny. I had one recently that it was opposite. It was like when they did when they got the square footage, it was actually more than what the assessor has, you know? So like, oh, do we fix it? And I was like, well, unless you want to pay more taxes, right? So I mean, the reality is that, you know, somewhere along the line, sometimes it happens. We find that when people have done additions to their houses, you know, then the assessors can kind of get that goofed up a bit. Something gets inputted because now you're entering math into the equation, you know?
Yeah, or situation where you can step out that they didn't pull any permits because the assessor's office doesn't have the right square footage, and
Right, or the field cards are wrong or something to that effect.
the assessor is following the building inspector in the same time he's
Mm-hmm.
final sign off, so that they make sure that they get their tax money.
Yeah, they've really sort of eliminated that in a lot of towns. For example, even Oxford, where our office is, you can't get signed off on your building permit until the assessors come in and take a look at it.
Yeah, for
So
sure.
that's been a real push. A lot of towns are doing that now.
Yeah, exactly. So there's discrepancies. It's good to dig into that early on.
Right, to try to eliminate some of those.
All right, anything else? Otherwise, we'll finish up and call it a day. Any other questions out there? Guess everybody got the answers they needed.
Great. If anyone needs anything, I'm available. Email,
Patric,
whatever you like. Give me a call.
your phone number.
Yep, 508-987-0222, and I'm here to answer anything they may have, or, you know, questions that come up. Like I said, to me, it's better off just asking up front, and that way you're avoiding half the stuff down the line.
For sure. I mean, I've worked with you guys a lot and my personal clients and recommended to use you a lot of our agents' clients. And it's because you guys just have a great team over there, you know, and
Appreciate it.
Amanda and Darren, you guys, I know you guys got some new people over there too that are doing a great job as you guys are growing, but it's key having a good team for sure, because you can't be everywhere all the time. And, you know, I know Amanda does a great job of, you know, keeping deals moving in the right direction and being, you know, reminding everybody of dates when they're coming up due. And it's a big thing, especially when you're a busy agent. You know, yes, you should always have your eye on the ball too, and know when the mortgage contingency is coming up. But you get into a car accident, you know, God forbid you get into a car accident or something happens in your personal life. It's good to know that you have someone else watching out too, for sure.
Yeah, like I said, we always try to stay on that. I mean, we always tell our agents that we do work with that, you know, we feel as though that agents are always best out doing what you guys do best, and that's selling, you know, we do what we do best, which is to protect everybody, you know. And so the more time you can spend selling and the less time you can spend worrying about protecting everybody, you know, as this process goes on, the better we're at, you know. So we feel as though that when the file comes to us, that we want to handle as much of it as we possibly can, and we sort of roll with that as much as you want to do. I mean, you know, I can remember we used to handle deposit checks, right? And that's not there anymore. And I got some agents now get their own water readings. So it just depends on how you want to handle it. But we try to stay on top of all of that. We have a lot of processes down, the backup process, and we're not missing dates, and we're not, you know, running around scrambling for those types of things. And again, trying to communication is key for everybody. So we try to, you know, like I said, we're all trying to be, at the end of the day, we're all trying to be on the same team, you know, trying to get things rolling to be in the right spot. So I appreciate the good words.
Makes the deal go better. That's no doubt about it.
That's right.
All right, that's all I have. Thanks for joining us today, Patrick. It was
Appreciate it, Chase. Thanks for having me.
an awesome hour, and I'll record this and send it out so everybody can see it that missed it, and appreciate your time.
All right. Thanks again. Appreciate it.